All right. You didn't successfully complete your pretrial diversion.
Judge, that's what the file shows. Ms. Hernandez believes that she did. Now, I contacted the pretrial diversion units. I didn't talk to her caseworker. I talked to somebody else, and they confirmed she did not complete it. She still thinks that she completed it. So what we want is a reset if we could. I want her to be sure. I want her to talk to her caseworker to get it from the caseworker. She didn't complete it. If she did not complete it, when we come back, we're going to do a plea. We have a plea agreement, and all we want is a short reset. When we come back, either we're going to find out the pretrial diversion was completed as a mistake, or she's going to do a plea.
All right, Ms. Ferguson. On Robin Hernandez.
I mean, just, am I correct? Is that what you agreed to do?
Yes.
And when you come back and take a plea, one of the part of the plea is you're going to go to rehab, and you'll go into rehab right then and there that day, right?
Yes.
You'll be taken to custody.
All right, Ms. Ferguson, can we set this in 2 weeks for a plea deadline date? All right, your plea deadline date is going to be August 24th. Do you understand? They're going to give you a reset form, and then you're excused.
Judge,
Yes.
it looks like I'm going to do a murder case on the 21st.
All right, let's do this.
So give me the Friday before or right after that week.
Norma?
Yeah.
He's going to be in trial. So let's do this. Instead of doing it the 24th, can we set this for the 15th? Is that good?
For September?
August.
Oh, 15, yeah, sure, yeah, yeah, that's. Yeah,
Yes.
what's the day? Today's the 10th.
Today is the
5 days.
10th.
Because I'm trying to get.
No,
All right, so we're going to do August 15th.
that's it.
He has a bond, or he does not have a bond set on that particular case. He has bonds on all other charges that I'm also representing him on. The
Mhm.
prior bond was $8,000. I was just asking the court to set a bond.
All right. On this one, you'll need to file a motion with me, or either you can have it referred to Judge Nahara. If you want to walk down to Judge Nahara's court and see if he can take it, he'll
Sure.
perhaps take it.
Okay, Judge.
All right, and here's the B page. Simulations.
So our office called Carruthers Court to check like what's else, because he's obviously on bond. And so they're supposed to reach out to him
Mhm.
to schedule the appointment with the doctor.
Okay.
It's actually done. Yeah. Oh, okay. And so nobody has reached out to him. And so we checked, and Carruthers Court said that there's some issue just with the coding in the system, that the motion for competency was granted, but something in the computer system is not coded properly.
Okay.
So that's what I'm going to try to figure out with the clerks. But the point is, we don't have a disposition on his competency at this point.
All right, Ms. Ferguson, on Shane Riley, I need a 45-day reset. Mhm.
And I will say despite his hardships, he's been very good about coming to court
Mhm.
and following rules as best he can.
Okay.
So, September 21st.
All right, September 21st, and counsel, if you can keep in contact with Judge Carruthers.
I will, Your Honor.
All right,
Thank
and they'll
you.
give you a reset form, then you're.
Okay, now that we understand what's happening, this is bigger than it sounds. Pretrial diversion isn't just paperwork. If completed, the case can disappear. But if the court record says it wasn't completed, she's back facing a felony DWI, third offense. That's serious prison exposure. And here's the tension. She believes she finished it. In court, belief doesn't matter. Documentation does.
Today.
Okay, so I was going to let the court know, we cannot get a hold of Mr. Longacre. We've been trying to get a hold of him for.
I know. So we're going to have another attorney placed on it.
Okay, is it just a plea and?
Oh, it's a sentencing. And the agreement is for probation. We just need somebody to stand in for the sentencing.
Is it a set term already?
Is it a set term
I'm sorry?
is it a set term of probation?
Yes. Could I see the file on Yvette Martinez? Yes. All right, so we'll just put that on the record that you're withdrawing the exhibits. And before we do that, there were three exhibits.
I did find them and I have them for you. Yes,
Okay,
yes, no, you were correct.
all right,
I'm
so
old,
let's put this on the record. And of course, counsel, if you want the court to hear your argument, the court will hear your argument and make a ruling. But since you're saying you do not, if you could have your client, Mr. Thomas, come forward. Oh, I think he's sitting there. Mr. Bias. Oh, that looks exactly like his client on the front row. All right, the court is going to call 2021 CR 4470, State of Texas versus Richard Thomas. Can I have parties announced for the record for the state?
Ruben Herrera for the state.
Defense?
Dr. Baez on behalf of the defendant.
And are you Mr. Thomas?
Yes.
All right, so counsel, you had sought to introduce into evidence defense exhibits 2, 3, 4, 5, and I believe defense exhibit number 14, is that correct?
That is correct, Your Honor.
And also defense exhibits number 12 and 13.
That is also correct, Your
All right. And the court had a 412 hearing, and today the court was going to hear argument for both parties on whether or not the court should allow those exhibits introduced into evidence, correct?
That's correct. That's correct, Your Honor.
All right. And we did have a hearing, and that hearing was in camera under seal. So, Mr. Bias, are you informing the court that you are withdrawing those exhibits and not seeking to introduce them?
Your Honor, that is correct. After doing some research last night and going through the exhibits again, and I was trying to hold for the exceptions to the 412, 609, modus, so on and so forth. And I don't believe I'm going to be able to get there, not at this time. So as a result, Your Honor, we're going to withdraw all those exhibits if we are allowed.
Okay, so the defense is seeking to withdraw defense exhibits 2, 3, 4, 5, 12, 13, and 14. Any objections from the state?
No objections from the state.
All right. And then counsel, if you believe that at some point in time, those are relevant and you're able to introduce them, that will still need to be done outside the presence of the jury. And of course, the court will hear whatever argument parties has.
That will only happen, Your Honors, as we see it if the exception arises. But as of right now, we cannot.
All right. And then with regards to defense exhibits 8, 9, and 10, we were missing those.
Your Honor, I found them. The court reporter told me, and so she hounded me. She threatened me. No.
Okay.
And so I found them.
All right. And those exhibits were not offered into evidence. Those were just used with regards to the CPS caseworker.
That's
All
correct.
right. Is there anything else?
Nothing from the state, Your Honor. I guess just in anticipation of anything going further, and that any allusion to any of those exhibits be brought up before the court outside of the presence of the jury prior to going down any line of questioning.
If I believe that exception has to arise, I will approach the court. I will ask.
All right. So we'll start the trial at 1 p.m.
Thank you, Your Honor.
All right. Thank you.
Thank you.
Thank you. Court is calling 2023 CR 1876, State of Texas versus Yvette Martinez. Can I have parties announced for the record for the state?
Jason Garahan.
For the defense?
Jonathan Chavez for Ms. Martinez.
Are you Miss Martinez?
Yes.
All right. This case has been rescheduled more than once. And it was due to the fact that Miss Martinez.
Listen carefully. A competency motion was granted, but it wasn't coded properly in the system. That means the court doesn't even have a clear status on whether the defendant is legally fit to proceed. This isn't drama. This is due process. If someone is incompetent, the Constitution requires proceedings to pause, and one computer error can delay everything.
Your Honor, the attorney who has been assigned, we have been unable to contact him for the past 3 weeks. We have spoken with both the state and Ms. Martinez, and we're comfortable with going forward with sentencing today.
All right. Miss Martinez, are you prepared to proceed? You're going to need to speak up.
Yes.
All right. And you're prepared to proceed with these attorneys?
Yes.
All right. So in this case, you entered a plea of guilty to count one on June 5th. The court requested a PSI and TAP evaluation. Have both parties had a chance to review the PSI and TAP evaluation, state?
Yes, Your Honor.
Defense?
Yes, Your Honor.
Any objections to the PSI or TAP evaluation?
No, Your Honor.
And I forgot to put this part on the record. Ms. Martinez, have you had ample time to speak with the current attorneys?
Yes.
Okay. You entered a plea bargain agreement. According to the plea bargain agreement, your punishment was to be assessed at 10 years in the prison. The state is opposing your application for deferred adjudication. They are recommending community supervision. There's to be restitution to the complainants in the case. And there are stipulations about your location. Did you understand that as the plea?
Yes.
Okay. Counsel, is there anything you wish to say on behalf of your client?
Your Honor, we just ask that you follow along with the plea agreement of the 10 years probation.
Okay. State?
Your Honor, the state is in agreement following the rec here, Judge, opposed to the deferred, and also to follow the tax recommendations.
And that's correct, Your Honor.
Okay. All right.
Your Honor, may I speak with may I speak with the client real quick?
Yes.
Thank you. Something's just been brought to my attention.
Okay.
Just a brief.
Motion to revoke. Are you all ready to proceed?
We're not, Your Honor, we need a contested hearing on this.
All right. And again, you go to the center. You're on that side. Your client is in the center.
Self-centered person.
All right. State, when will you be ready for this contested hearing?
I can defer recommendation.
Sure. All right. So Ms. Ferguson, I need this reset for 2 weeks.
And Your Honor, because the defendant was being supervised on probation out of Tarrant County, would it be possible to have his probation officer from Tarrant appear via Zoom?
It depends on whether or not the defense is going to object to their appearance by Zoom.
We would object, Your Honor.
All right. So just let them know to appear here. All right. We'll recall this for September 24th and have,
August 24th.
I'm sorry, August 24th. And we'll have that person here by Zoom. So just so everybody knows, this is a contestant. So when you come back on August 24th, of course, if somebody decides to plead true, I will hear it, but it's set for a contestant.
And just to be clear for the record, Your Honor, that's going to be in person.
In person.
Not via Zoom.
All right, in person.
Thank you, Your
Thank you,
Honor.
Your Honor.
You're welcome. All right, Mr. Smith. An attorney was appointed to you. My understanding from listening to the conversation with the court coordinator, the previous attorney, had you had any contact with him?
Not recently, no. I tried to call his office yesterday. He didn't pick up. They said they wouldn't call me back. Called him 5 times. He never called me back.
All right. So Mr. DeLeon has been appointed to represent you. So today was discovery date, but Mr. DeLeon, since you've just been appointed, I will give you all a reset. Ms. Ferguson, can I have a 30-day reset on this case, please?
September 14th.
All right, so we'll be back on September 14th. Mr. DeLeon, if you want and your client wishes to be back sooner than that, just let the court know.
Sounds good, Judge. We appreciate it.
All right, thank you.
Thank you.
Good morning. All right, so today's plea deadline date. What's going on?
Judge, we have a discovery issue. The defense brought to my attention that we thought we had provided everything, but there is a Nest video that neither the defense or I have. We thought we had it, but we have a photo from a text message of like, here's the Nest video. We don't have the video itself.
All right, do we know if the Nest video has been purged?
Well, so when defense brought this to my attention this morning, I emailed the manager of the bar where this occurred, and I haven't heard back from him yet. I emailed him this morning, Judge, and after docket, I'm going to figure out which SAPD property crimes email to send it to see if they have it. I believe that the bar owner or the bar manager sent it to SAPD already, so I believe they have it, but I'm not positive of that.
All right, Ms. Ferguson, if I can have a reset date in 20 days, please. and it's discovery. All right, we'll be back on August 31st.
Thank you, Your Honor.
All right, once you sign the reset form, you're excused.
Yes, ma'am. You have a good day.
You too. Eric Diaz. All right, and can I see the file on Barnett, please? Waiting for your attorney. No, Christopher Diaz. Barnett, Mr. Morris by Zoom. So who's doing it?
I'm here, Your Honor.
All right, Francis Barnett, come forward.
Hey, Cynthia.
Hi, how are you?
Good. Hey, Judge.
Hello.
I'm trying to stand. Like, check this out.
I'm sorry, what?
I said I'm trying to stand.
All right, thank you. Oh, please have a seat. So the state is still conferring on your case?
Judge, I'm sorry, we're ready.
Oh, okay. Things are just turning on a dime. All right, the court is calling 2020 CR 1567, State of Texas versus Francis Marion Barnett the sixth. Could I have parties announced for the record for the state?
Jason Garahan, Your Honor.
Defense?
Blakely Moore for the defense. And hey, Jason, nice seeing you, man.
See you too, sir.
And
Robert Steve Wilson, co-counsel for the defense.
all right, the defense filed a motion for early termination of deferred adjudication and then filed an amended motion for early termination of deferred adjudication. Have both parties had a chance to review, or state, have you had a chance to review the motion for early termination? No problem. All right, state, are you in objection?
Yes, Judge, we're opposed to the early termination.
All right, defense, you may proceed.
Yes, Judge, we presented this motion at the time that Mr. Barnett had taken this plea. It had we'd gone through several trial dockets, and he had been on a SCRAM monitor and ignition interlock for several years prior to us ever getting the case resolved, and he had no violations of any kind and had always abided by the court's order. At any time he wanted to seek modification of those conditions, he always presented himself timely and dressed properly for this court. Now, I know that doesn't weigh into whether or not to terminate a case early, but I just wanted the court to know that he's, beyond him being on this current supervision, he was under the strictest of bond conditions prior to. He also completed outpatient treatment, met with psychologists, psychiatrists, completed every condition of probation ahead of time. When I met with probation officer Cynthia Perez, who's on this call with us, he is a perfect probation.
Now we're entering early termination territory. He's compliant. No violations. Treatment complete. Restitution paid. But he hasn't reached the halfway mark. And legally, that matters. Early termination isn't automatic, especially in intoxication assault cases where someone was seriously injured. So the question becomes, does good behavior after the fact outweigh the harm caused? This is where accountability gets tested.
On merit to change him from the monthly, and Cynthia, maybe you could help me out. The check-ins at the house, what are those called?
For the field visits?
Yeah, so they were about to discontinue the field visits, not seeing that those were necessary anymore, which would just leave him on just checking in monthly and on ignition interlock. So Mr. Barnett consulted with us because since he took this plea, it's affected his ability to maintain gainful employment in the field he was in. He was in medical pharmaceutical sales. Obviously, traveling with ignition interlock, he can't do interstate travel because when he travels out of state and needs to take clients out, he can't rent a car without a vehicle with ignition interlock in it. Also, as he is trying to apply for new positions in this field or try to do lateral movements, what is coming up is the fact that he's presently on probation, and that he has been told that unless this is discharged, he can't pursue these things that would advance his career. And I told him that this is totally discretionary to the court. I assume the state would oppose it, but I told him it's, Wayne Gretzky says you miss 100% of the shots that you don't take. And we wanted to put it in front of the court. And then alternatively, Your Honor, if he was to be denied, I advised him that he could always pursue this again in the future. And we would ask the court at that point for some other modifications of his current probation, Your Honor.
Okay, and I see that this was originally an intoxication assault, and he entered a plea to count 3 and count 4.
That's correct, yeah.
State?
Your Honor, I think that really the state's position is this is not even at the halfway mark at this particular point. And on top of that, the initial interlock is supposed to be imposed until, I believe, 2024. So the state's position is that we haven't made it even the halfway mark. I know this was not considered a 3G because it was a plea to count to 3 and 4, which was an ag assault, SBI. But if this was an intox assault, to be considered that, and it would not be eligible for early termination, at least until the halfway mark. So I believe this is sort of a little early in the game to be asking for an early termination of his probation at this point, Your Honor.
All right.
Your Honor, may I add?
Sure.
One more thing. Mr. Barnett has been laid off. He is looking for a job. It's not just that it affects his ability to go enhance his career. He needs to go find a job. And therefore, you know, that's really what prompted this, is this need to find a job.
Okay. So what is precluding him from finding a job?
I'll let Mike answer that.
So when he's applied, Your Honor, just for the things I've stated before, when he has applied, and he shared these things with the probation department as well, but he, when he applies and they do a background check, it's not that he has this on his record that's precluding him. It's the fact that he's actively on probation, and that he has to travel domestically, interstate for bulk of his work and internationally in the medical and pharmaceutical sales business. He was doing quite well up until this tragic case, and which he did accept his portion of responsibility for. I don't know if Your Honor remembered the facts of this case.
Yes.
Okay, and so that's that he's being told by them exactly what's going on, and the fact that he is going to be obligated and was in his prior role taking CEO, Alphabet officers out for, the schmoozing, the dinners and the meetings, and he can't rent a car to go pick up the clients at this point because it requires him to have ignition interlock everywhere he goes. So it's both the background, them running his background and seeing he's actively on felony probation or deferred, and coupled with the fact that he is restricted in his ability to rent vehicles that are without ignition interlock.
All right, Mr. Barnett, I want you to realize that I'm internalizing everything that is being said to me.
Yes, ma'am.
But there are always consequences for actions, right? And the complainant in this case had a fractured pelvis.
Yes, ma'am.
Complainant's life is never going to be the same. Your life is never going to be the same because you're on probation. And with probation, there comes difficulties. And sometimes based upon what you're on probation for, that means that you can no longer work in the field that you were previously in. So I understand that you don't have employment. I understand that you can't get employment in the field that you were previously in. I understand that may mean that you're not making the money that you're used to making, but those are called consequences. So I always tell people you got to knock your pride aside and work wherever there's employment. If you have a savings, then if you want to deplete your savings, eventually you'll probably have to get a job. I think the cryptocurrency thing is done for. So you're just going to have to get another job. And guess what? I always tell people, even if that job is working as a fry cook, guess what? In this world, there needs to be a fry cook. In this world, there needs to be somebody to dig ditches. In this world, there needs to be somebody to bring crops in, and there's no shame in doing it. My mom was this close to working on a garbage truck because she had to support her children. And that was back in the day where you actually rode on the back of the truck, you got off the truck, and you picked up the garbage cans. And that was back in the day when people did not use trash bags. So if you can imagine it, and you know why she was going to do that? Because she needed to support her children, and she was knocking her pride aside, because I don't know anyone who wanted to do that, but she was going to do that. And then she got called for another job, but she was willing to do that. So sometimes we have to do what we don't want to do and there are consequences. So your consequence is, this is where you are. I'm going to deny the motion. And I always talk to people because I want them to know that I have listened to everything. And it's not just pro forma for me that I'm automatically going to deny something or not. But come back and have the term and I'll reconsider. We'll see where we are.
Your Honor, with you denying the motion, Your Honor, can I
Yes.
just an oral motion to do what probation was asking, which was to amend probation conditions to stop the community home visits that are monthly? That was something she was going to raise and asked me to piggyback that.
All right. I will tell you, I'm going to continue with those home visits until he gets employment. Once he has employments, then the court will consider eliminating the field visits.
And then Judge, just creatively knowing that the early termination has been denied and he's going to continue to be on deferred. And as Jason pointed out, there's no requirement. He has to remain on ignition interlock. And Your Honor, he has not had a violation in 5 years of monitoring. And he had the most restrictive conditions while we were on bond waiting for trial. He was on scram monitor for 2 years. He doesn't drink. This completely changed the way he approached life. He's done everything the court would ask to protect society. May we amend the bond or the probation condition related to monitoring his vehicles?
I'm not willing to do that at this stage.
Okay.
right.
And the other thing we were contemplating was, can we switch him to report by mail or pro forma? Since right now all he does is check in.
No.
So still monthly in-person visits?
Yes.
Notice the shift here. The judge brings it back to the victim, fractured pelvis, permanent impact. That's intentional. In probation hearings, judges balance rehabilitation with consequences. And sometimes the reminder is simple. You don't just serve probation. You carry what happened. That's the weight behind this denial.
Mr. Barnett has come several times to ask for permission to travel out of state in order to look for jobs. And when he worked, traveled to work. Can we lift the state injunction to go travel out of state for work?
He needs to, one, a motion will need to be filed. Two, he'd need to provide proof of that to the court. Then the court will consider that.
Thank you, Your Honor.
All right. You're welcome.
Thank you all. Nice meeting you.
All right. Thank you. Good luck with your trial. All right. Court is calling 2021 CR 5216 State of Texas versus Delphina Spiller. Can our parties announce for the record for the state?
Hank Wilkins for the state, Your Honor.
Defense.
Valerie Headland.
And are you Ms. Spiller?
Yes, I am.
Showing you what's entitled Motion to Enter Adjudication of Guilty and Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Yes, I did.
Are you the same Delphina Spiller who was placed on deferred adjudication in 2021 CR 5216 for the offense of possession of a controlled substance, penalty group 1, 4 grams to 200 grams on September 10th, 2021 for a period of 5 years? Is that you?
Yes, that's me.
State?
Violated condition number 5 in Bexar County, Texas. The defendant, Delphina Spiller, did then and there fail to report to the supervision officer as directed for the months of July and August 2022 in violation of condition number 5.
Are you plead to that, true or not true?
True.
State?
Your Honor, we waive and abandon the other violations alleged.
Any objections?
No.
Did you understand by pleading true to violation of condition number 5, the court could find it true, grant the motion, find you guilty, and sentence you up to 20 years in prison and up to a $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 5? Court will find violation of condition number 5 true. Is there a proposed agreement?
Judge, there's not a proposed agreement. We were going to recommend 5 years. I believe the defense would like to ask for an alternative to that, Judge.
All right. Defense, what are you requesting?
Judge, without going into so many details and background on this, and certainly not to offer excuses, Your Honor. I did meet with Ms. Spiller for a long time last week. She has had some serious health issues starting about the time that she did last reported to probation. And it had her in and out of the hospital from around June, July of 2022. September, they finally diagnosed her. And then she went septic and went into the hospital for 3 weeks in November. I don't think she was in a right frame of mind at all. I did ask her, why didn't you just pick up the phone and call probation, call the court? She was eventually picked up because, well, she was in Spring Branch. And then after she resolved some of the medical issues.
Was she supposed to be in Spring Branch?
No, Your Honor. Her mother-in-law lives in Spring Branch with her children. And her mother-in-law was administering the IV antibiotics and everything that she was going through. And her mother actually has custody. Is it one daughter or two? Just one daughter. Because of a very serious incident that happened with her eldest daughter in 2017. Ever since that date, I think Miss Fuller's life has spiraled out of control.
And has she picked up any new offenses since
That's
she
the
was?
problem. She has 2 new, excuse me, number ones out of Comal that are for misdemeanor charges that are from September of 2022, all along the same kind of time frame.
And what are those charges?
I think fraud, use, possession,
Failure to identify.
failure to ID. There's an offense report in the summary.
All right. And so she has fraud use. And I will tell you that in this plea bargaining agreement with the case, they took into consideration fraud use cases.
Yes.
And so I have before me a person who's not reporting and is alleged to have picked up new fraud use cases and didn't pick up the phone and call probation.
Yes, Your Honor. There, you know, she knows not to just stand before you and make excuses or say it's a mistake. She knows that. But in the Comal report, at least, she was with a person that got charged heavily with other items and issues, and she was coming out of the Tractor Supply. So there's a paragraph in there that addresses her. The majority of the report is for the person that she was with.
All right. The person she was with, does he have criminal charges?
I would imagine so, based on that.
And she's not supposed to be around people who have criminal charges.
Yeah. I would ask Judge, this is her first MTR. And the charge is a 2nd-degree felony, her underlying, from 4 to 200. It was 5-point-something grams of meth at the time. So if that's any consolation, I would beg that she be allowed to continue probation. At worst, sentence her for the convictions. And I think she's on the bird. And then place her back onto probation so that she can seek additional help and support. She is with her sister now back in San Antonio. I think her sister is a good influence and is helping her. She also suffers from diabetes, Your Honor. She's having vision loss, so she can't read the paperwork that I give her. She had a doctor's appointment scheduled for July 27th that she missed because she was taken into custody on this case. That's why I asked the court to bring her a little bit quicker. So, I would just ask that she not be sentenced to TDC. I realize there's not really an alternative placement for her, like treatment, because she has charges pending in Comal that I can't really do anything. I don't have any influence in those cases. So we're just asking the court to, if at worst, sentence her, revoke her, but put her back on probation since she's never been to TDC.
All right, Ms. Spiller, there are consequences for actions. I am going to grant the motion, find you guilty, revoke, sentence you to 5 years in the prison, give you credit for any time served. There's a $500 fine, time and money rent concurrent. If you would like, I can ask that you be placed in the therapeutic community. I have no jurisdiction for you to be placed in the therapeutic community. You'll have to ask for it as well. But the therapeutic community is helpful in any type of drug issues that anyone may have. Would you like me to request the therapeutic community?
Yes.
All right, I'll request the therapeutic community. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
I did.
All right, you have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion. not the fact that you were on deferred adjudication. Do you understand? Because this is I'm sorry, you need to speak up.
Yes, ma'am.
All right, because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
This is the turning point. When a defendant pleads true to violations, the judge regains full authority to sentence. No agreement here. Missed reports. New charges. Health struggles mentioned. But legally, reporting is a core condition. And then comes the number. 5 years. This is where second chances narrow.
Sure.
But also there was an overlook on my part that SATF residential treatment was the recommendation. There were two options and I overlooked that. So Mr. Garahan pointed that out.
Yes.
And that's what I pointed out to the client. And I would ask the court at this time for more time for sentencing, Your Honor.
All right, so Ms. Ferguson, wherever Kenneth Longacre is, he needs to be here. So does anybody have his number? I will call him. All right, if you will text me his number, and if he wants to appear by Zoom, he can appear by Zoom. But this case is going to happen today. The complainant keeps coming down every single time. I know Ms. Martinez keeps coming down every single time.
I think just myself personally being ineffective for arguing.
No, I understand. Thank you.
But he was approved for DDRF.
All right, so then, Ms. Abrams?
Yes.
On Adolph Lopez, they said that he's been approved for DDRF.
He has been approved for DDRF and he already has a condition for DDRF. I have placed an email to ensure that he's already been placed on the waiting list.
All right.
Thank you.
And I am writing that in the file. All right, thank you. Yes.
So on this thing, like they said, okay, what's going to happen? If you don't mind asking.
You can ask any questions. What's going to happen is you're going to remain in custody. Then you're going to be transferred to a facility that will handle any type of mental health issues that you may have.
I don't got mental health issues.
Okay.
I'm a rich man, you know.
Yes.
Basically, my other probation officer
Mhm.
and my probation says get out. You know what I'm saying? So I don't know why on this charge
Mhm.
I go from state hospital
Mhm.
and then he gets involved. Well, where's my other lawyer at when he said I was in jail? And
Okay.
they get switching up lawyers on.
All right, so this is what's going to end up happening. So I'm internalizing what you're saying. I want you to internalize what I'm saying, because I want to make sure that you don't have any violations on your probation. I want to make sure that you're not getting into any type of trouble. So what's going to happen is you're going to wait at the jail. They're going to take you to a mental health. Wait a minute. They're going to take you to a mental health facility. When they examine you there, if they say everything is okay, I will immediately get a report. We will immediately bring you back and you will immediately be released. You understand?
Yeah, but
Okay.
What about the probation?
Oh, you'll still be on probation.
That don't make sense though. Like,
I know.
I mean, I know that they got so much a grudge against me because
Who has a grudge against you?
I mean the people, you know.
Yeah.
You know, my dad, I'm rich, you know what I'm saying? So I mean basically
That
they
can
tryna
cause
hold me.
jealousy. Yeah.
Yeah, I know. And
Okay.
basically my dad's waiting on me to get out, you know what I'm saying?
All right. So are you able to, do you have your father's address? Are you able to write to him?
What they're doing is wrong, you know. I can say it over and over and they can hate it all day. I don't, but basically I'm trying to go home. I don't need to be mental. I'm not mental. I'm basically.
All right. I tell you this, let's do this.
This is a waste of time.
No. Let's do this.
Whatever.
Let's do this. When you go to the jail, I want you to write a letter. I want you to, or either call whatever relative you want to call. And guess what? If they come into the court and they want to speak to me, I'll speak to them. Okay? That's what I'll do.
But I want to know what's going to happen. How long? What?
All right. The first thing that's going to happen is you're going to go back to the Bexar County Jail.
How long am I be there?
Right, wait, let me finish. First step, you're going to go to the Bexar County Jail. Second step, from the Bexar County Jail, you're going to go to the DDRF facility. Third step, A doctor's going to see you there. And they are going to make sure that everything is happening, what should be happening with you. Fourth step, once they tell the court that you're okay, or your attorney tells me that you're okay, or your attorney tells me he wants you brought back, we'll have you brought back. All right? Thank you.
Okay, well, when am I getting released?
After you go to DDRF. So once you go to DDRF, then you'll be released.
Okay, and then I could go get by my mansion.
Okay. It's calling 2021 CR 2977, State of Texas versus Crystal May Martinez. Can I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense?
Megan Enriquez for Crystal May Martinez.
Are you Crystal May Martinez?
Yes, ma'am.
All right, counsel, you were appointed on this case today. You do have 10 days to prepare. Do you still wish to proceed?
We wish to proceed today and waive the 10 days, Your Honor.
All right, Ms. Martinez, do you understand that your attorney has 10 days to prepare?
Yes, ma'am.
Do you still wish to proceed?
Yes, ma'am.
All right, I'm going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Crystal May Martinez who was placed on deferred adjudication in 2021 CR 2977 for the offense of possession of a controlled substance, penalty group 1, less than 1 gram, on September 21st, 2021 for a period of 3 years? Is that you?
Yes, ma'am.
All right, state.
Violated condition number 4 in Bexar County, Texas. The defendant, Crystal May Martinez, did then and there fail to report to the supervision officer as directed for the months of June, July, September, and October 2022 in violation of condition number 4.
How do you plead to that? True or not true?
True.
Your Honor, state waives all the violations.
Any objections?
No objection, Your Honor.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes, ma'am.
Court will find violation of condition number 4 true. Is there a proposed agreement?
Yes, Your Honor, it would be, it was a proposed agreement for revocation, 250 days in the state jail facility.
I'm sorry, how many days?
250.
Now the energy changes completely. When someone begins talking about mansions, wealth, jealousy, during a mental health discussion, that signals possible competency concerns. The court isn't punishing here. It's making sure the defendant understands reality and the process. From the bench, this is protection of due process. From the defendant's view, it feels like injustice. And this moment shows how complex criminal court truly is.
Credit for any time served. Going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes.
Because this is not a plea bargain agreement, you do have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you are on deferred adjudication. Do you understand? You need to say yes or no.
Ma'am.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand?
Yes, ma'am.
If you would like, I can refer you to the therapeutic community. The therapeutic community does not increase the time that you're in custody, but they would be able to help you with any type of drug issues you have. Would you like therapeutic community? All right, good luck to you.
Would you like to?
Ma'am, I like it. They said I didn't do
Hold
anything.
on, hold on one second.
Yes.
Your Honor, can she have a brief moment to address the court? She would like to tell the court, like what she did do on probation.
All right, can you raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Crystal Martinez.
All right, so what did you do while on
Like I
probation?
did report, I have 4 months that I reported and I did do the drug hotline. I didn't always test, but I did do my drug. I did call it almost every day and I did drug test a couple times, but I did report for 4 months. It was when they switched my probation officer from missing one time that I was supposed to report that they switched. That is when everything started messing up, because she would send me an email telling me when I had to go in and report, and then turn around and send me another email telling me that she changed the day I had to report and give me a new date to report.
All right, so I want you to internalize what you told me.
So yes, I messed up. I'm not, but like.
No, but you just told me.
I didn't do my
that
classes because I can't afford a $285 class.
No, here's the thing. What you've informed me of is that you were doing the UA hotline and sometimes you didn't test.
No. but I was on, but the days I didn't test, my probation officer knew that I wasn't gonna test.
When you're supposed to test, you're supposed to test. It's not calling your probation officer, telling them that you're not going to test.
I'm saying she knew I wasn't gonna, because I was in her office with her, signing the paperwork.
All right.
So this is pointless, because I'm still gonna do it here.
Well,
All right, who's here on?
Your
Yes.
Honor, just can you also admonish her that there is good time credit in the state jail facility, and
Yes.
it's possible she can only have to do 80% of the time. Is that
It
correct?
doesn't matter, I didn't wanna do it here.
Okay. All right, thank you.
Sure, thank you.
Who's here on Shalice Schutz? Yes, where is she?
She is not here. This is an off docket matter. I was conferring with the state and they suggested that we should approach with this. Ms. Schnitz is the sole caregiver for her child. She has a meet the teacher tonight. The state's willing to allow her to go to the meet the teacher. But we also need her to be able to pick up and drop off her child from school. It's 1.5 miles from her house.
Okay, how do you spell her last name?
Schnitz.
That's not what's on this.
I'm sorry, Your Honor.
So the pronunciation is not the best.
I apologize.
Haven't we already been here for this?
I don't think this.
Not this particular motion. Your Honor.
Yeah, it was set recently.
Yes, and it was for her to go to school. Can somebody pull and see? Because I remember this case. And it was for her to take her children to school.
So we couldn't come to an agreement on that, Your Honor. So I think that we were going to set it to Mr. Nakata or to Judge Nakata.
Mhm.
But the urgency, there has been a development in Ms. Schnitz's personal life where she's the only person who can take her little girl to school.
Okay, here's the thing. I'm not doing tracking only. That's what's in this motion. So I'm not doing that. She is on bond for manslaughter, intoxication, manslaughter.
And so what I was,
I'm not removing the urinalysis requirement.
she's also on the drug patches is the.
I understand. So you're all in agreement to her being allowed to attend the meet and greet teacher?
Yes, Your Honor, which is tonight because of the.
And then they were leaving it up to the judge or to the court about whether or not she could pick up and drop off her child from school, which is all we're asking for today.
Well, technically, we're leaving everything up to the court, but
Clearly.
we would rather be heard on the dropping off every day.
Because I don't even have, there's no time in here for drop offs and anything with regards to the school. So with regards to that, you will need to have your client here and the court will hear the motion on that.
Should we do that tomorrow, Your Honor?
We're in a jury trial tomorrow. So if you want to do it on Monday, we can do it on Monday.
That's the only thing is that's the first day of school.
Yeah. If y'all want to have Judge Nahara hear it, and if the state is going to waive their notice, then you can have him hear it, but we're in trial. All right, and
So with the GPS, they can see that she's taking her child to school and then coming back home and then picking her.
the rules are the rules. I'm not doing tracking only. The only thing that you all have agreed to today is that she is allowed to do the meet the teacher from 6 p.m. to 8 p.m. Is that correct?
That's correct.
And that's for today. Anything else, you all need to come back.
And we're not asking for tracking only, Judge. We're just asking that she be allowed to pick up and drop off her child from school.
No, that's what it says. So defendant is requesting to be allowed to be monitored on tracking only.
We're modifying that orally if we could.
Okay. All right. Here's what it'll need to be a different motion. And let me see a B page, please, on this case. It's 2023 CR 5651. And everyone else, the court is breaking at noon. And then we're going to take up Mr. Longacre's matter.
Yes, Your Honor.